Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near, in the attendance, you shall be heard. Please be seated.
Exciting, everyone. Yeah. Good afternoon and welcome to the Appellate Division First Department. Please, I want to remind you that we have had your briefs and records and had a chance to become familiar with your cases. So we ask you to please just ask for the time you really need. When the light goes on, the red light, that means you're kind of finished up with your statements. If we have questions, we will continue asking them. So I'll call each case. Please rise if you're here, both sides, and let me know how much time you would like. The first case is People versus Joshua Brown. Submitted. Clifford versus White Plains Hospital.
Richard Tracy for the appellant, White Plains Hospital, Dr. Torres and Dr. Straff, 5 and 1, please.
Okay, and the other defendant?
Yes, Your Honor, Jacqueline Mandel from Calvin, Borges, and Ryan for Hospital for Special Surgery, Dr. Weiss. May I have 7 and 3, please?
And plaintiff?
Plaintiff requests 5 minutes.
Okay, let's do 5 and 1, 5 and 1, and 5. If there's additional things, we'll deal with it then. M. Sharon versus Elmer M. is submitted. People versus Francisco Mariano is submitted. Ezra Zones versus Rudd.
Good afternoon, Your Honors. I'm Albert Chang on behalf of the plaintiff appellant Ezra Zones. 15 minutes, if I may.
And how much does the other side want?
11-4, please.
Good afternoon, Your Honor. Laura Flatt from Skadden on behalf of the defendant respondents. 8 minutes.
Okay, I'm going to give you 8 and 2, and I'll give you 8. Okay, thank you. North Flats versus Belkin Burden.
Good afternoon, Jeffrey Goldman of Belton Burton, 8 and 2. Please help.
And respondent?
Good afternoon, Your Honor. Dan Abrams for the respondent. 8 minutes, please.
Okay, 8, 2, and 8. Agosta versus Abraham.
Good afternoon, Joshua Turkowski for the appellant. 8 and 2, please.
Carol Ann Herlihy for the respondent, 7, please.
Okay, I'm going to do 6, 2, and 6. If there's additional questions, we'll continue on. Parlux Fragrances versus Carter Enterprises.
Good afternoon, Your Honor. Anthony Viola for the appellant, requesting 9 and 6, please.
And respondent?
Good afternoon, Your Honor. Elodie Thompson from Mandel Urquhart and Sullivan on behalf of the respondents. 12 minutes, please.
Okay, so I'll do 8 and 3 and 8. Thank you. People versus Jared S. Submitted. Almonte versus Consolidated Ed is submitted, and Board of Managers versus Montbatten Equities is submitted. Okay, the first case for oral argument is Clifford versus White Plains Hospital.
May it please the court.
Good afternoon.
Deirdre Tracy from Aronson Rappaport, Feinstein and Deutsch. For the appellants, White Plains Hospital, Dr. Torres, and Dr. Straff. Plaintiffs are in agreement with my clients that my clients are responsible for treating the condition for which the plaintiff came to the hospital on October 2nd, based on the symptoms as they were when he presented to the hospital. We know that eventually the plaintiff was diagnosed with a cervical spinal abscess, but at the time of his presentation to White Plains Hospital, his sole complaint was of right.
Why do you think, why is there, it seems to all circle around the blood tests. So why is it not that it was a breach of the standard by not getting a blood test, or at least drawing blood?
Well, that dovetails from one of the other, I was about to say,
There's a lot going on here, but that was
right,
something that
the
came.
characterizations, plaintiff's characterizations of the symptoms when he presented to White Plains Hospital. And one of the things they do in order to try to take this case out of the long line of cases that say that no liability can ensue for failing to investigate an otherwise unindicated condition is to, in one instance, focus on the temperature at presentation, which was 99.1 degrees, and select that temperature.
So the bottom line is, you don't always get a blood test. There has to be certain things that you have to like check some boxes off before a doctor says, I think I'm gonna get a blood test.
Correct. You have to look at the whole entire picture of the plaintiff's presentation. And in this case, he had just been doing kickboxing and slept the wrong way. And this was not, at that point, intractable pain. It was new onset pain. This was his first presentation for this pain. And when you look at taking the allegation that there was fever or symptoms of fever, the expert focuses on just that one temperature at intake, doesn't actually say that it was feverish, but that it was borderline. By looking at that one temperature, it doesn't consider that the plaintiff had just been hovering over the hood of a car sweating, and also doesn't look at the whole picture where he had denied any sort of fever or chills coming into the hospital, and eventually that temperature settled down. The only evidence of any symptomatology at the presentation at White Plains Hospital was solely for the right lower back pain.
In fact, did he get painkillers, or he was given some,
He was.
and it worked, right?
Yes, and everything seemed to resolve, and everything was consistent with his history as he came in and as his presentation and symptomatology, that this was a musculoskeletal issue that came from the kickboxing and perhaps sleeping the wrong way, rather than that it indicated some sort of infectious process at a different area of
So he had radiculopathy, correct? He was suffering from
right down
lower,
the right.
So
right.
why not palpate the entire spine in those circumstances? Or is it your position that's not standard of care because there were no symptoms with respect to the spinal?
Correct. There was no, both plaintiff, he even testified to this. There was absolutely no symptomatology at all, but the neck or even the shoulder was all down here. So there was, on the physical exam within the record, I believe it was page 215, where they indicate that there was no vertebral tenderness. It was just paraspinal, outside from the spinal. So we're talking about a situation where it's in the wrong, it's completely different area of the back, the cervical area versus the lumbar, and it's also the back, not the spine. So there was no indication here that there was a spinal condition or a cervical spinal condition, and to the extent that any sort of infectious etiology should have been considered, both Dr. Straff and Torres indicated that it was, and for that reason, they ordered the urinalysis. And the urinalysis was ordered because that was more consistent with, if there was an infection, with where his pain was, his complaints of pain were in the lower back.
Who ordered the MRI? Was it your clients that ordered the MRI, or was it HSS that ordered the MRI?
It was in between.
Somebody ordered
In
the
between,
MRI.
correct.
Okay. But nothing from the record would cause the physicians here to do an emergency MRI, like get it done now, like yesterday.
Correct. That's exactly the position that and if you look at, again, this is purely just the lower back, and when you're talking about someone who had just been saying how he'd been doing all this kickboxing and slept the wrong way, that correlates perfectly with what his symptoms were at that time. It was not a prolonged, intractable pain as it later developed to be. So on the presentation solely on October 2nd, there was no indication to do any sort of cervical workup, any further infection workup, or any spinal workup. The workup they did was related to his symptoms at that time, which was for the lumbar back pain, paraspinal.
In opposing a perceived prima facie showing for dismissal, did plaintiff's experts against White Plains and your doctors establish any kind of departure in the manner in which he was treated?
In the manner in which they investigated the lumbar?
Yeah.
They talked about that perhaps another scan should have done, but that is in order to try to make the leap from a lumbar condition and the symptoms that he did present to then incidentally discover the cervical condition. And that's where, again, the facts of this case fall squarely within that long line of cases that I believe it's Curry and Perez, that doing a further investigation, you can't be faulted for not doing a further investigation of the condition to incidentally discover a condition that just is not indicated. Unless there's any other questions?
Okay, you'll have a moment for rebuttal. Thank you.
Good afternoon. May it please the court, my name is Jacqueline Mandel, and I represent Hospital for Special Surgery and Dr. Weiss in this matter. So I have two issues that I'd like to address. With the court's permission, I'd like to start with an issue that pertains only to my clients, and that is that the plaintiffs failed to raise a triable issue of fact because they did not submit competent expert
Their
proof
expert, correct?
in
Their
opposition.
expert gave was basically, from what I can gather or read, was he read articles and all the other medical texts out there, but didn't state that he actually did any kind of actual hands-on work, right?
That's
Am I
right, Your
reading
Honor.
that wrong?
So my client is a physiatrist, sometimes also known as physical medicine and rehabilitation,
management.
pain management, precisely. The plaintiff's expert specializes exclusively in emergency medicine. And there is nothing in his affirmation to say that he has any of the qualifications. So in this court, the rule.
What about the other expert, Dr. Blass, who made some comments about or opined that the defendant should have ordered blood work that they did not order? He had some qualifications.
So Dr. Blass is their causation expert. He's the infectious disease expert, the same as mine. But before you get to causation, of course, we're talking about the standard of care. And their
There
standard
was no departure.
I beg your
There
pardon?
was no departure in the affirmations.
Correct. Not from the infectious disease expert. He did not say a word about departure. He's just there talking about how the infection works and how long it would have been there. And his position is it had to have been there. But he doesn't assert any departures against my client. So the rule in this court is that a qualified expert has to profess personal knowledge of the standard of care in the field of medicine at issue. Justice Gessmer, that was your holding in Bartolacci. Justices Schulman, Justice Kapnick, those were your decisions in Greenspan and Newell, cases that are cited in my brief.
Counsel, doesn't work serving as an emergency room doctor require managing pain as well?
It may require managing pain, but this case is about a cervical epidural abscess, and the plaintiff's emergency medicine expert did not state that he knows anything about it. He never stated that he has ever treated a single patient with that condition, in sharp contrast to both of my experts who said that they've treated innumerable patients with this condition. He had never stated that he ever treated one. And I wanted to point out that, in order to circumvent this issue of expert qualifications, the plaintiffs in their brief decided to completely change the narrative, recognizing that an emergency medicine expert really isn't qualified against a physiatrist who treats patients in his private office. The plaintiffs in their brief said, well, this isn't really about physiatry at all. This is about forming a differential diagnosis. So I really need to address that because, it's just simply not true. First of all, when we argued the motions before Judge Edwards, if you look at page 45 of the record, you'll see the quote from plaintiff's counsel who specifically tells us that, I'm quoting from that page now, the most critical aspect of Dr. Weiss's failure is not as much that he did not take a differential diagnosis. He says a differential diagnosis is really focused on the emergency room physicians. So on top of all of that, of course, it's just simply...
Let's go to the malpractice part.
Sure. So
Was there any symptomology that plaintiff, when your doctor treated him, that plaintiff may have a cervical abscess?
there definitely was not, Your Honor, and this was the other point I was going to get to, which is the unindicated condition argument. My client is the one who ordered the MRI.
And apparently, did he not go to the MRI where it was scheduled? He went to a different place?
That's right. So in between the plaintiff's presentation to White Plains Hospital and the one office visit with
Which
me,
was like two or
he
three
saw
days.
a chiropractor twice, including on the very day that he saw my client, but he saw the chiropractor in the morning. And the chiropractor got on the phone with the plaintiff's insurance company and managed to get an authorization for the MRI and scheduled an appointment for the plaintiff to have the MRI at a radiology facility out on Long Island called Zilka Radiology for October 6th. When the plaintiff comes to my client orders an MRI to be done at HSS. The plaintiff decides to have the MRI that's already been approved by his insurance company, and he goes there on October 6th. Prior to that, though, to answer, if I may answer your question,
Yes.
there's not a single symptom. It's undisputed. There are very few things that everybody agrees on in this case, but certain things that everybody agrees on is that the plaintiff showed up with absolutely no pain anywhere other than in his low back and his right leg, no pain in the neck, no nuchal rigidity.
How severe was the pain when the plaintiff presented to your doctor?
Quite severe, 10 out of 10.
So at that point, should there have been more of a differential diagnosis with respect to maybe a cervical condition?
Well-
based on the level of pain, which obviously progressed from when he was at the hospital a few days earlier.
So my answer to that question, Your Honor, is maybe, even if we said, arguendo, that the lumbar MRI should have been done emergently, that has nothing to do with what's going on in the neck. If Dr. Weiss had sent the plaintiff to the hospital for an emergency MRI of the lumbar spine, we would have found out two things. One, the anticipated diagnosis of a herniated disc impinging on a nerve would have been disproven. And two, there would have been no infection, no tumor, no abscess, no nothing in the lumbar spine. We would have found out that the man has pain in his lumbar spine from something.
What about the trigger point injection, which your doctor did give him when he came in there? And they're claiming that there was some type of relationship between that injection and ultimately what the condition he ended up with. What about that? I mean, what caused that to be given, and where exactly was the trigger point injection?
Okay, so the trigger point injection, my experts explained, is a muscle injection. It's not a spinal injection. And my experts were very detailed about the fact that the plaintiff was always saying it was an epidural injection, something that's, literally given into the epidural space. When the plaintiffs found out that that wasn't true, they abandoned that argument. There's nothing in their brief about trigger point injections. There's not a word in either of their expert affidavits about trigger point injections because they recognize that a trigger point injection couldn't possibly be connected. A trigger point injection giving all the way down here in the low back can't possibly be connected to something in the intervertebral space up in the neck. And so the plaintiffs have abandoned that issue. And I guess I'll save the rest for
Let's
reply.
hear from the plaintiff, and you'll each have a moment or so for rebuttal. Thank you.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff respondent in this matter. Just a couple of points to start. With respect to the qualification issue of the expert, I would refer the court to 645 of the record, paragraph 4, Dr. Silverberg's affidavit, sentences 2 and 3, in which he says that most of this, and I'm quoting, is basic medicine with which I was already familiar as a physician of emergency medicine for over 20 years. And we know that based on the Joswick case, you don't have to be a specialist in order to opine as to a particular departure.
But how do you explain that he never treated someone like the patient here?
Well,
I'm talking about Mr. Silverberg, right?
So the answer is that...
Dr. Silverberg,
Yeah.
I'm sorry.
I'm sorry, Judge Schulman. The answer is that the theory of the case is this. And let me tell you what I'm not saying, because there are some implications as to what our claim is and what our claim isn't. I have a 6'7" 325-pound athletic guy, no prior history in his 40s. He comes in with a complaint that he was kickboxing, and he's a fit guy, firefighter, right, FDNY. The first thing anybody would assume in that situation is that he has some orthopedic problem. I would too, all right? I was an athlete in school, that's what you do. Here's the problem. There is a procedure set forth by both of my experts, and they say it deals with differential diagnosis. Medicine is an art, it's not a science. Yes, something could be likely, but in medicine, things don't always pan out. So what do? My experts say you do two things. You do a radiographic image, I think it would be an MRI, but it could be a CAT scan, and you take blood to make sure there's no infection, because you could always have an infective
But
process.
based on what? If the patient may be borderline fever, why would a physician then go ahead to perform a test which may then may lead down the road to find, in fact, there was an infection?
The test that they're talking about, Your Honor, Judge Singh, is a lumbar MRI. I want to knock out the cervical versus lumbar distinction. Those defendants take the position that because there was no cervical pain, That means that there's a difference between the lumbar and the cervical epidural. That's not what my expert said. My expert specifically said that that wasn't true. 647, paragraph 10, second sentence. This is what he says. I'm quoting, not anyone else. This isn't Brian Isaac. This is the expert. Mr. Clifford was suffering from one continuous infectious process between at least September 30th, 2017, the reported date of the symptom onset, on October 6, 2017, the day that the infection abscess was diagnosed, caused by the MRSA infection that was finally diagnosed and treated at Good Samaritan Hospital on October 6, 2017. Mr. Clifford's signs, symptoms, and complaints between September 30th, 2017 and October...
So what symptoms did the plaintiff have that would lead a reasonable doctor to give a differential diagnosis to include the...
He had the lumbar pain coming in. You do a radiographic test to assure that there's correlation between the lower lumbar injury and the complaints. And if there is, if the MRI, right? So we know that MRI and CAT scans were done on the 6th. We also know that Dr. Jagoda, which is their expert, took the position, and I want to quote what he said, that the MRI and the CAT scan were, quote, entirely unremarkable and entirely benign. Double adjective with entirely.
So if they found that, what would lead them to do anything else?
Because now you have pain that is inconsistent with a condition. If
Well, wait,
that
hold on a second. When the plaintiff is at the hospital, his pain levels aren't that high. They're treated by meds and they come down. It changes. I agree with you when you get to HHS, but first dealing with the hospital. What more should the hospital, or what more could the hospital have done?
Wait, so let's go back to how the accident happened, right? This isn't a guy who comes in after kickboxing and say, you know, I hurt myself, or takes a swing on the golf club and says, you know, I have a wrench back. He's lying on the hood of his car, he can't remember. He's got pain 10 out of 10. One of my adversaries said to you the pain went down. It went down, but it didn't go down. It went down to 7 out of 10, 6 out of 10, and then back up to 7 out of 10 while he was on multiple narcotic medications. So this is not some minor little thing when you look at the records. And I'm not suggesting to you that if the MRI, if they had done the MRI, my adversaries would be 100% right. If they did the MRI and the MRI came back as being pathological for a lesion in the back that would result in low back pain, they have no responsibility at all. Because under a differential diagnosis scenario, they've now matched the complaint with the condition. They didn't do that. So if we disprove, and that's what our expert says that the MRI, the word he uses is disproves the pathology for the back, you have to look at something else. It could be any number of things. It could be something that's not really expected, because that happens in medicine, but that's what differential diagnosis is. And when you read the defendant's own testimony, they say that that's how you do a differential diagnosis, that you have to rule out infection at some times, and that they actually considered it. The problem here is with the lack of the initial testing. They didn't do two things that they should have done. One, they should have taken some radiographic tests, which they didn't, which we now know by reasoning backwards would have shown that there was no pathology at all.
So
And you do a blood test.
hindsight 2020, I mean, isn't that what we're doing here? Is that we're looking back and saying, well, that should have happened?
Not at all, because I'm sorry, I didn't mean to cut you off. The initial standard of care, as attested to by the plaintiffs, based on the Court of Appeals decision in Toth, is when someone comes in with this condition, which is a lesion, you have to rule it in or rule it out. That has nothing to do with anything that went on in the past. They didn't do two tests. Now, do you have to reason backwards to show causation? Of course you do, because it's a failure to diagnose case. And when you have a failure to diagnose case, you don't have the information that one would normally have, because the gravamen of the claim is that the doctor or the medical provider failed to do something which doesn't give the necessary information.
Isn't the implication of what you're saying that whenever someone presents with pain, that the doctor must do a blood test?
No.
Even if there are no other symptoms of infection?
Let me give you two scenarios, if I can, Judge Gesmer, okay? And I like to use sports just because I was an athlete. It's easier for me, okay? If I'm on the golf course and I swing my golf club and I go, oh, my back hurts, that's one situation where perhaps these doctors don't say that. But when you're taken to the emergency room because you're actually passed out on a car with 10 out of 10 pain, that's a different scenario. This isn't a minor little thing. And apropos to the questions that the court has given to me, if you take a look at his conditions, They never got better. They always worsened. I actually wrote them down because I couldn't remember them. But if you take a look at this, worsening condition included severe, intractable, progressive pain, pain unchanged by positional foci, focal tenderness on palpation. There's potential fever, which you probably know about. I don't have to go into it, whether it's borderline tachycardia or borderline hypertension or borderline fever, diminished reflexes, motor weakness, pain undiminished despite medication, and swelling. So his condition wasn't ever getting better. It was getting worse, and he had a preventable condition because the experts say that this started on the 30th, and ultimately on the 6th, when they finally did the test and found the MRSA infection and how it grew, he had already been septic, and the focus of the abscess was so large that it covered C1 to C5. They already killed the cells. So this is still a summary judgment motion. And to me, when you look at the competing expert affidavits, the trial court got this one right.
I just want to go back to one minor point.
Sure.
They did do a urinalysis.
They did.
And my understanding, I could take judicial notice of it, but a lot of times urine can show a white cell count that would suggest infection, correct?
That's what they said. Our expert said.
And there was information here that the 3 to 5 white blood cell count, I'm not sure if I'm pronouncing it or properly determining that quantification or value, didn't really suggest any major red flag.
If I may, if you read the defendant's brief and you read my brief, the urinalysis wasn't normal. They quantified it and said, well, there was some abnormalities with respect to it, but it wasn't pathologic for, say, an infection. But our expert says, look, you just do a blood test. And again, when we have summary judgment motions in medical malpractice cases, unlike other cases under the Toth decision, the standard of care that you apply is determined by doctors, not by lawyers, not even by judges. It's different from that. So that's the standard of care that they had. He's in the hospital, right? They can order the MRIs emergently. And how hard is it to take blood if you're in the hospital? If you're ever in the hospital, they take blood all the time. So this is not a situation where I'm suggesting to you that they have to do everything all the time, but in this situation, with this confluence of facts, including that he was in the emergency room twice in 3 days, and you have 2 doctors saying that there's a breach of this standard of care on a summary judgment motion, you should affirm the trial court's decision. If you have no more questions, I'll sit down and let my adversaries talk to you.
Thank you,
Thanks for
Mr.
listening.
Isaac. You have a minute for rebuttal.
Thank you. Just a couple of quick points. One of the points they make, again, as I touched upon in my opening argument, is about this idea of this was actually a failure to do a proper differential diagnosis case. And as I'd mentioned, that's an attempt to take it out of the long line of cases that are really dispositive of the action here. And one of those things was the failure to consider an infection. And as Judge Schulman, you mentioned, they did consider an infection, and they considered an infection consistent with the symptoms that he was showing, and that's why the urinalysis was the testing that they did for the infection that any infectious etiology that considered, because that was something that would have been consistent potentially with the symptoms he had. So what they're proposing, and I'll use some of his language that he said, was that it could be any number of things that they should test for. And that's why, because we know later he suffered from something that was completely unindicated on October 2nd, they are reverse fashioning all these any number of things that should have been done, including.
So what you're saying is what the plaintiff is suggesting or arguing is that there should be an expansive now where you have to keep searching when all your symptoms only have into a certain area.
Correct. And I think Dr. Silverberg, I believe it's on page 658 of the record, there's a good block quote of what he says. It's like, if they'd done this, then they would have seen it wasn't this, and then they could have done this, and then they could have done this, and then they could have done this. And that's not consistent with either the standard of care, and certainly isn't consistent with the case law in this department. So unless there are any further questions, thank you.
Thank you.
You know, it's really.
I have a question. Following up on Mr. Isaac's comment, it seems part of what he's arguing is, well, there would have been no harm in taking blood. It's so easy to do that once he's in the hospital. why wouldn't that be an appropriate part of the standard of care?
I didn't treat the patient in a hospital. I have a guy in a private office, and the claim against me is that I should have sent him to a hospital. And then you have a whole bunch of speculation on top of speculation about what these hypothetical emergency room people would have done with the patient if my client had sent him to a hospital.
But even in your client's office, it wouldn't be that hard to draw blood.
But you wouldn't get a stat result like you would in a hospital. So he could have drawn blood, but this all would have happened, and we wouldn't know it. I need to address what Mr. Isaac said about this idea of there's no separation, there's no distinction between the cervical spine and the lumbar spine, and that this is all just one big process. I mean, that is just not true. There is not a single symptom, not a single complaint, not a single sign that this patient expressed, exhibited, or was found on clinical examination that there was anything wrong with his neck. And it is for that exact reason that neither of the plaintiff's experts ever criticized Dr. Weiss for failing to send the plaintiff to the hospital to get testing of his neck. All over Dr. Silverberg's affirmation, he criticizes Dr. Weiss for failing to send the patient to the hospital to get an MRI of his lumbar spine because that's what was hurting him. But there's nothing. They don't tell you anything. While my experts have put forth detailed explanations for what you would expect to see for a patient who is suffering with a cervical epidural abscess, and they talk about nuchal rigidity and photophobia and exquisite pain at the site of the infection and not in some distant or distinct anatomy, their experts don't say that. They just say he had indications of something really dangerous going on in his lumbar spine, and you needed to send him to the emergency room to have imaging of his lumbar spine so that you could find out that your anticipated diagnosis was wrong, so that then a whole bunch of other tests could be done. But what's never, ever, ever explained is why any physician would have gone on after getting a negative MRI of the lumbar spine and started looking at the neck when every symptom that this man had was below his waist. Why would they have been looking at the, this is obviously rhetorical, but there is no
What
explanation
about the
for
severity
why.
of pain? Could the level of pain, because the pain levels were very, very high, no question about that. Would that be a basis maybe to say that more testing should be done to ascertain where the pain's coming from?
Sure, more testing, Your Honor, but why the neck? I mean, could have been a kidney stone, right, causing excruciating, severe, unbelievable back pain. Could have been gallstones. Could have been an abscess somewhere in his abdomen, somewhere in the vicinity of the pain. But this man is moving his arms and legs, he's breathing, he's not short of breath, he's moving his neck. My doctor is the only one who did an examination of the cervical spine when the patient came to see him. He's the only one who looked at the neck, and he found no cervical region tenderness, normal cervical spinal strength and stability. Everything is moving, normal range of motion, and he's moving his arms and legs, and he has no alarming neurological symptoms that you might relate to the cervical spine, like no bowel or bladder dysfunction, no paresthesia, no paralysis. He's in a lot of pain in his low back. He's having trouble walking. He's got pain radiating down his leg. None of that explains, and the plaintiff's experts never explained why anybody would be looking at anything above the waist, much less the neck. And so the plaintiff, in our view, did not raise an issue of fact, and summary judgment should be granted. Thank
Okay,
you.
thank you. Thank you all very much. The next case for argument is Ezra Zones versus Rudd.
May it please the court, your honors. I'm Albert Chang, appearing on behalf of plaintiff appellant Ezra Sons, a Barclays shareholder residing in New York. Before I start, your honors, I want you to know that I'm not a native speaker of English, and if you do not understand anything due to my accent, especially under this high ceiling, please let me know, and I will allow me to clarify. No offense will be taken. I'll do my best to make a clear record. Your Honors, this appeal is about a New York resident shareholder's access to New York courts to bring derivative claims on behalf of foreign corporations doing business in New York. The trial court was wrong in applying the procedural requirements of English law to this case. We ask that this court reverse the trial court's dismissal order on two.
So your argument is based on BCL 1319, correct?
One of our arguments based
Well, your
on.
primary argument.
Yes.
But when I look at that, isn't that simply a statutory predicate for jurisdiction? Isn't that all that the statute is saying? I know we have to deal with Culligan in a few minutes, but if you look at the statute, isn't that a way of interpreting the statute?
No, Your Honor, here's why. And I take it that Justice is saying you're referring to the line of cases, the line of trial court decisions, including the Stephen Blau case that you authored in
Yes.
2015. The way we look at Article 13 of the Business Corporation Law and Section 626 of the Business Corporation Law is this. Section 626 says that a derivative action may be brought on behalf of a line of holders of, including holders of beneficial interests of corporations, both foreign and domestic. In our view, that is the jurisdiction vesting provision in the Business Corporation Law. And here comes Article 13, including 1319, that says that the following provisions shall apply.
So it's essentially based on a statutory analysis. You're asking us that we should essentially throw out 50, 60 years of precedent based on the statutory analysis you're making.
Not at all, Your Honor. We embrace the internal affairs doctrine. In fact, in our complaint, we invoke the internal affairs doctrine to assert derivative claims, the substantive claims, based on English law. We have no problem applying the internal affairs doctrine for in the common law sphere.
Well, except for when it comes to standing. I mean, and that's what we're talking about.
Except it comes in Article 13, when the New York legislature has spoken that these following provisions, including Section 626, the gatekeeping provisions for shareholder derivative lawsuits, shall apply. That is the decision of the New York legislature for the protection, after balancing the interest for protection of shareholders, the interest of the management of foreign corporations, and the overriding public interest.
Does it matter if
of
the
New York
foreign,
being the center
excuse me,
of the
counsel,
world.
does it matter if the foreign corporation, in terms of contacts, have hardly any contacts to New York, or has substantial contacts in terms of supporting your argument? I mean, or is this across the board you're arguing any foreign corporation, because of 626 and 1319, they're automatically going to be brought here? We have standing to bring these lawsuits.
The matters part is in the plain text of 1319.
But no, so you're going to say that all foreign corporations are subject, or shareholders, holders of securities, or holders of shares of foreign corporations, they all have the ability, or they all have standing to bring a derivative suit in New York then?
That's exactly what Section 626 says in its plain text. And Section 1319 adds an additional requirement of foreign corporations doing business in New York.
So does it matter or does it matter in terms of the presence in this state?
It matters to the extent that 1319 requires it. And in this case, it's almost a
You
non-issue.
didn't answer my question. The presence, how much presence needs to be in this state for 1319 to be triggered?
So long as there's presence for the court to assert personal jurisdiction over the defendants.
So doing business.
Yes, doing business.
Is the predicate.
Yeah, and that is CPLR 302 requirement. And we obviously.
Just how you're saying that the internal affairs doctrine there's an interplay with the internal affairs doctrine, and as my colleague said, and doing business. I mean, if you're not doing business, the internal affairs doctrine is going to prevent the derivative lawsuit. But if you are doing business, the internal affairs doctrine cannot preclude you from bringing the.
Yes, we agree with that statement. So
So on this record, did your client meet its burden in establishing it was a member? For purposes of the ECA, which requires a membership to have standing to be able to sue?
If English law applies, that's what the trial court held. Obviously, we're also appealing that
So
decision.
you believe English law doesn't apply in this case?
Correct. English law does not apply here because the New York legislature has spoken. All holders of
Assuming English law, the ECA does apply, did you meet the standard that you're a member? Were you registered under the ECA to be qualified as a member from Barclays?
none of the ECA requirements should apply in our case.
You didn't ask my question. Assuming it did apply, did you satisfy the requirement of being a registered shareholder to be deemed a member?
We alleged in our verified complaint, that is page 750 of the record in paragraph 30 of our complaint, we allege in our verified complaint that Ezra Sun's shares were registered and he is, the corporation is a member.
But
under the
wasn't there evidence presented by the defendant that they had gone into the ledgers and done some research, and that it was very clear that on the important date, you were not a member? So, I mean, can't we consider that?
No, Your Honor, and we believe that the trial court was wrong in considering that because that evidence, that affidavit was hearsay. The person who testified that my client's name did not appear in the share register did not have access to that register. And we allege in our verified complaint that the client is a member under the ECA. And the ECA, it's page 961 of the record. The ECA defines member in both registered members, members who are registered in the company's registry, and other people who become members by operation of law. That is an unsettled question.
I'm sorry, I didn't mean to cut you off. I know I found it in the record, but I didn't record it, but in your opposition memorandum of law to their motion to dismiss in a footnote, the counsel admitted that your client was not a member, could be a member, but was not a member. So that, to me, strikes me as an informal judicial admission, assuming the ECA applies. You don't agree with that, sir?
No, we do not agree with that because here we have a verified complaint, and under CPR 105U, subsection U, the verified complaint constitutes an affidavit.
All right, why don't we hear from the respondent? We will give you a few minutes. You have a few minutes for rebuttal. Thank you.
Thank you, Your Honor.
May it please the court, Laura Flath from Skadden Arps on behalf of the defendant respondents. The questions that this panel has
Let me
asked.
focus on the doing business part.
Sure.
What does Barclay do? To what extent is Barclay doing business in New York so that we can arguably accept the 1319 roping in 626A? Because it seems like that's where the rub is, right? As my colleague points out.
Well, certainly there are
Because
multiple.
Culligan, I don't think, we've all seen the cases post-Culligan, since I was the initial
Indeed, Your
person on Culligan, right? It sort of seems like it's sort of really restrictive and narrow in terms of what they were doing because Culligan had different kind of facts. What are the facts here for Barclay?
So, Your Honor, below we did raise the point that in fact there is no subject matter jurisdiction here over Barclays PLC. And the references to the companies matter. Plaintiff likes to sort of say Barclays writ large. In fact, the nominal defendant is Barclays PLC, which is the holding company. And the allegations that are raised in the complaint relate specifically and only to subsidiaries, Barclays Bank PLC, Barclays Capital Incorporated, and those, as pled, are not enough to establish that, in fact, Barclays PLC is doing business. So, in fact, there actually is no subject matter jurisdiction.
The reverse process is they're trying to get the parent through the subsidiaries, and that's not how it's.
Correct, Your Honor.
Water doesn't flow up, it flows down.
Precisely. And in fact, there's nothing here with respect to the parent company, and that distinction does matter. It matters in this court's precedent, and that's been held consistently. So first and foremost, there is no subject matter jurisdiction here. The trial court sort of passed that thorny piece and went immediately to the issue of standing. And precisely as Justice Singh was asking, there is no reason why Section 1319 should be considered as anything other than a statutory predicate to jurisdiction.
But the argument is logical. I mean, there's a logical argument to be made that there's a jurisdictional hook in it, based on the interplay of the two sections. How do you respond to that?
In that, because the internal affairs doctrine has still continued to apply here. And in Culligan, the one case that they've cited to sort of show this, every other case that has considered this issue, expressly including whether 1319 is a choice of law provision, has said no. And in fact, the text and the legislative history support that reading. So all they have is Culligan to rely upon. And in that, the facts are very different. The Court of Appeals, subsequent to Culligan, this court, subsequent to Culligan, have all said the internal affairs doctrine still should apply, including with respect to the issue of whether there is standing for a derivative suit against a foreign corporation. So you can consider it if there's doing business, which they have not even gotten to, but the internal affairs still says for purposes of stability and all of the reasons why you're going to want to look to where a corporation is incorporated, that you really should consider, is it a substantive or a procedural requirement? Membership, whether you're under the Companies Act, the ECA, or English common law, is a substantive requirement that this plaintiff cannot meet. And to go to the other points about sort of why, in fact, the trial court did get it correct and this plaintiff is not a member, Justice Shulman's point on the concession and the admission by counsel is exactly on point. Plaintiff jumps immediately over that and goes straight to the Elwood affirmation, which we certainly submit that Justice Reed properly did consider, but you don't even need to get there. Their counsel admitted in a written pleading in multiple instances, that's record 939, in footnote 9, as well as in other places, also record 939, that they could become a member, but they hadn't. It would be time-consuming, it would be difficult. They are simply not a member, and whether you're under the ECA or even English common law, that ends the inquiry, which is why Justice Reed did not even need to deal with the sort of the thornier issues of doing business or not. Respectfully, there is no subject matter jurisdiction. That's a basis for affirmance. We raised that as well in our brief, and certainly, while this court can look at the questions that Justice Reed decided, it's absolutely entitled to dismiss the complaint on alternative grounds.
So going back to Culligan, how should we distinguish Culligan? Because Culligan, when I was in the trial court, I could say what I want about it. I'm not there anymore.
Absolutely.
How do we
Yeah, he sort of backed me up afterwards with a subsequent decision. Thank you very much.
Indeed, he did, Justice Wang.
I
So
knew I was always right.
we absolutely maintain that earlier decision on Culligan was of course on point. Culligan, even this court, has recognized that Culligan does not need to be read with the broad brush that plaintiff applies to it. Just last year in Eccles, for example, this panel clarified that in fact, to the extent that litigants and courts were reading Culligan to stand for the proposition that the internal affairs doctrine does not apply to former directors and officers, that's wrong. So that certainly already...
Because that statute, I can't read the 1319 as, 1319, it is what it is. It applies to foreign corporations. I can't believe that that's getting rid of the common law. I mean, so clear as to get rid of the internal affairs doctrine. I mean, you gotta be, when you're doing something like, and you have to understand when this was written and how it's all playing out. I can't believe that that's what the statute of 1319 stands for.
We would agree, and there has been no other court that has held that that is what 1319 is intended to do. That's why the Court of Appeals in Davis versus Scottish Re applied the internal affairs doctrine to consider standing, and why this panel has continued to do so.
Because that would mean that every single foreign corporation, regardless, is going to be subject to a derivative lawsuit here in New York. That's it, because if I were to accept plaintiff's argument, 1319 does exactly that. It doesn't matter what's going on here. It just means I can bring a foreign corporation here, derivative lawsuit, regardless of whether or not I meet the foreign corporation's home rule or home substantive law that says you have to do X, Y, and Z. I mean,
that would be exactly right, and we submit that is exactly not what is supposed to happen here, and that would be upending, in fact, 60 years of precedent if, in fact, that is what the court would do and overturn the motion to dismiss decision. In my
In
final,
that sense, we wouldn't be respecting the other jurisdictions' laws.
absolutely not. And in fact, the UK has implemented that law through the ECA, and it's also recognized it in common law. There would be no stability for directors, for officers, for companies assessing risk or knowing at what points they would be subject to lawsuits in this derivative context.
Well, other than that, you can see a lawsuit being commenced across the pond, and then they're going to come down with decisions telling the other way, saying, no, you can't do that.
Absolutely. And that recognition of comity is exactly why the membership requirement is a substantive provision and should be respected under the Internal Affairs Doctrine. In my last moment, it really didn't come up, but we also filed a motion to strike particular materials that were submitted as part of the record. We addressed that in our papers, but we certainly think that those should be excluded.
Thank you.
Thank you, Your Honors.
So let me just first start with this point with Davis versus Scottish Re and the Mason Mahon versus Flint case. Those two cases constitute an independent ground, independent of 1319, to reverse the trial court, because under Davis and under HSBC, the entire ECA provision, sections 260 to 264, they were all procedural and as a result cannot be applied to any proceedings in a shareholder derivative lawsuit in New York. With
Is
regard,
there any case post-Culligan that is interpreting it the way you have interpreted it?
no, Your Honor, and this court will
What?
issue.
In New York State, is there a case that says essentially that the statute overrules the internal affairs doctrine of a corporation?
Not in New York post-Culligan, but I bring your attention to the Norton case from the Second Circuit in 1984 that says exactly.
Which is what Culligan cites, as I recall.
And in our view, all courts are duty-bound to implement a statute and implement the legislative intent based on the plain text of the statute. Section 1319 says what it says. All foreign corporations doing business in New York shall be subjected to the following provisions, and one of those provisions is Section 626.
Yeah, and let's just say I buy that argument. Let's say, assuming I buy that argument, then the next hurdle is doing the business aspect of it, right?
Correct.
I mean, it's not a free-fall. You can't just get past one and just say, I'm in. Now you got to get, there's another hurdle that's in front of you. And the argument is that you're going after the subsidiaries and not the parents. So how do you go reverse that and try to get at the parent?
A couple of things, Your Honor. The records replete references of what Barclays has done and what Barclays has done through its subsidiaries. We have Barclays has paid billions of dollars of fines through its subsidiaries and itself to the New York Attorney General and the New York State Department of Financial Services. Barclays and its subsidiaries has been off litigants in courts, in federal and state courts in New York. Barclays owns a sports arena in Brooklyn. Barclays has a building in Manhattan. From our perspective, saying that Barclays is not doing business in New York is absurd.
But is that the branch of Barclays that's being sued in this case? You're collapsing everything that Barclays owns together, aren't you?
One of Barclays' main subsidiaries, the Barclays Capital Incorporated, is one of the defendants, and Barclays PLC itself, the parent company, which is a holding company, which is a shell, is also the nominal defendant.
Okay, we will take a look at your papers again. Thank you both very much.
Thank you, Your Honor.
The next case for argument is the North Flats versus Belkin Burden. Good afternoon.
Good afternoon, everyone. My name is Jeffrey Goldman. This is Michael Bobick. We're Belkin, Bird, and Goldman in this legal malpractice action. We submit the trial court erred in denying summary judgment on the record that was before the court, and we believe upon reversal, not only should we get summary judgment dismissing, but on our counterclaims, both under 8303A and Rule 130, and our counterclaims for unpaid invoices, which are not opposed, must be granted.
Mr. Goldman, where on this record is there information that would suggest that it was reasonable for you to rely on the architect's opinion, if you will, that there was full compliance, so that you can be comfortable with the notion that you were shocked in August of 2021 to first learn that they had it all wrong?
I think that question flips what an attorney should be doing. It shouldn't be that perspective. I think the perspective is, and again, on the record, and let's remember the record here, like the court used in Tribs, there's an unverified complaint, no affidavit from the plaintiff, no affidavit from the architect, no documentary evidence opposing anything that we have. So the issue before the court, and it's framed in the first cause of action, is we failed to apply for an extension of a milestone deadline. That was the December 24 deadline. So the question
Implicit in that is that you were relying on the truth in the architect's affidavit without there being anything in your papers that suggests that you advised the architect on what was required in that form, on any kind of check as their counsel to make sure that the architect understood the significance of what he was signing. It seems to me that that's an ordinary duty of due diligence that an attorney would do before submitting such an important document.
Well,
And that having simply relied on that, you then didn't have the option of, you claim that you didn't have the option of later withdrawing it or making an application for an extension. But the first issue seems to me to come from your simple reliance on that without questioning it. And there's nothing in your papers that I recall that suggests you did otherwise.
Okay, a couple of things on that. There is no legal authority that an attorney is supposed to challenge the expertise of an architect.
Mr. Goldman, let me interrupt you. We're not talking about legal authority challenge. We're trying to understand what the standard of care is. And I think what we're getting at is that, my colleagues suggest that may be part of the standard of care. Maybe I disagree. But it seems to me that you need an expert affidavit saying this is what a reasonable attorney would do under the circumstances when they get the form and file the form. No, the filing of the form is ministerial, there's nothing more to do. But we don't have that information. So it's hard for me to know what the standard of care is in this very, very technical area of the law.
Well, a couple of things. The standard of care, if you look at in the record 26 to 30, the emails of Mr. Bobick to North Flats. Mr. Bobick writes, I want to confirm that you're...
I saw the emails, but the question is does the attorney, as my colleague was asking, have an independent obligation to do more than just take the form, look at it, and file it, or should the attorney, or a reasonable attorney, would go over the form with the architect to make sure it's done properly for all the reasons you stated in the email, or your client stated in the email?
If the architect, the short answer is no.
But based on what? I don't have an expert affidavit say that's my biggest problem with your case. Not to say you're right or wrong, but there's no expert there telling me what the standard of care is.
It is, when you say a standard of care, it has to rise to a level, any more so than in a malpractice case where any expert that any client retains. We didn't retain the expert. We didn't talk to the expert. We didn't suggest the expert. This is their expertise with fire and safety compliance.
I don't know if anyone's really questioning the expertise of this architect, just like what is the standard put upon an attorney practicing in this area of law, which lots of people don't do because it's very technical. We spent this morning with election law. That's also technical. There's a lot of technical areas. Do we know what an attorney under these circumstances would do? Should they have sat down and spoken to the expert? Not because the expert wasn't an expert, to make sure everything was checked out, was gone through well, so that you wouldn't have the problems that came out where all the tenants started questioning and raising problems and not paying rent as of January 2021, I think it was.
The email, and I know you've read the email after Mr. Bobick says, I want to make sure it's right because there could be problems. And the client then says, the architect is reviewing, I will confirm with him. He then writes back that the architect has reviewed and it is good to go. I think Mr. Bobick, frankly, went above and beyond, not just taking it at face
But
value. Because
shouldn't there have been someone other than you saying the attorney went above and beyond, someone that was an outside expert that said, this is the standard of care that I would expect of an attorney practicing at this time in this area of law in New York City?
honestly, Your Honor, we moved for summary judgment. It should have been on an unverified complaint with no affidavit where they didn't allege a duty of care. As far as breaching, they simply said, we missed the deadline. That's all they said. They didn't say that we shouldn't have, nowhere in their unverified complaint, nowhere do they say we shouldn't have relied upon the client's architect.
But it's your motion for summary judgment. You have the burden in a malpractice case in the first instance to lay out a prima facie. Generally, we require, as you saw in the prior malpractice case, expert opinion, because we don't set the standard of care. It's set by the experts, in a sense, by the lawyers who practice in that field.
We believe on the record, again, where they don't raise that issue in their complaint, and we have in the record what Mr. Bobick did. If that wasn't the standard of care, they could have raised it in the opposition to summary judgment. They didn't. Thank you.
Okay, let's hear from your, from the respondent, and you'll have a few moments for rebuttal. Thank you. Good afternoon.
May it please the court. My name is Dan Abrams. I represent the plaintiff, the North Flats LLC. I believe it is undisputed from July of 2019 to August of 2021, the Belk and Burden law firm represents.
Counsel, let me ask you a question. Do you agree with counsel that the sole ground for malpractice that you allege is defendant's failure to file an extension application to extend your time to achieve 7B compliance, or do you allege other forms of malpractice besides, other events that constituted malpractice besides that?
They never spoke to the expert. They never,
Where do you allege that in your
that's
complaint?
their admission.
Do you allege that in your complaint?
That's not an argument that I believe was made until today. I'd have to look.
But you start with the
crux of the
complaint. In your
complaint.
complaint, did you allege that that was malpractice?
I'm sorry, what was the question?
So the case starts with the complaint. Did you allege in the complaint that their failure to talk to the expert was malpractice?
I don't know sitting here. I'd have to look at the complaint. I would say this, though. They did not file for an extension, and had they spoken with the expert and understood what the expert was saying or not saying, they would have educated themselves. I mean, counsel is right. The primary allegation in the complaint was the failure to file an extension.
And the failure to file an extension, as I understand, was, from the defendant's point of view, unwarranted because they relied on the architect compliance form being filed, which was timely filed, and that the certification was good. So what's the point in seeking an extension? Because they thought everything was good.
Right.
So, and then, notwithstanding that, there was initial meetings at the law board, everyone was meeting, they realized things weren't, and the tenants were not happy with the certification and started having questions about it, and when rent started getting withhold, and eventually you had the famous August meeting where everything blew up, and then your clients fired them or sought substitution. And then they then started suing and hence their counterclaim for fees now. So as I understand it, your complaint central position is their failure to get the extension. And then by putting that front and center, their position is their failure to seek an extension was because they didn't need to. And so then on this record, there was no expert to be able to evaluate that they didn't need to do this, correct?
That's correct, Your Honor. And I'm thinking through the complaint. We probably did not allege in as many words that they didn't talk to the expert. I don't know how we would have known that. But when counsel moved for summary judgment, they said we didn't talk to the expert, and we didn't talk to him until we found out in August in front of the loft board that, there might be a problem with the certification. That's the first time they talked to the expert. And, you look at pages 89 and 90 of the record, which is the actual architect certification.
So I have a question.
Yep.
Counsel was arguing, and I saw the emails, that he's relying on your client saying we're good to go, okay? That's what we have here. And, you heard the argument that this is he has to establish prima facie his burden in terms of awarding summary judgment. Did you put in an expert affidavit in opposition to raise a factual issue saying that by his argument relying on the client's affirmation, or at least good to go, is not the standard of care? Did you put anything in there for that, to raise that factual issue?
No, Your Honor.
Because that's a big point he's hammering with, unless I was somewhere else. That was his argument this morning. It's like, look, we got an email from the client. Okay, assuming we had a duty to go further, we told the client, look, what's the architect doing? The client comes back, I'll check, and then comes back later, everything is good to go. There we go. So.
Well, I agree with Your Honor. It's a huge point, but it's not our burden to put in an expert affidavit.
I'm just saying now, let's just say, assuming that they established their prima facie, you can take that approach. It's not my burden. It's not my burden. When I was so many years ago, you always take the opposite just in case to cover your bases, right? So what do you say to that?
I say that we are on a pre-discovery summary judgment motion. We don't have their documents other than the selective paper presentation that they gave in. And it is not our burden on a pre-discovery summary judgment motion to submit an expert report. And I was going to say, there are 38 different code provisions in the architect's certification. 38 different code provisions. Obviously, there are going to be the possibility, at least, of close calls, reasonable disagreements. Two intelligent people, one says there's certification, one says there's not certification. This is a realistic.
In my mind, the individual that really has all the answers is the architect, but you're suing him too, so he's going to stand on the sidelines, not saying anything.
Well,
right? The architect pretty much knows what went down, right?
Not necessarily, Your Honor.
Well, he'll know who he talked to.
There's no evidence in this record that the architect has knowledge about the loft floor. The evidence in the record is Belkin Burden gave my client a document, said, this is for you to deal with the architect. No communications. Architect signs it. We're good to go. That's not legal advice.
Are you saying that your client would have retained an architect to deal with the loft law who knew nothing about the loft law? That seems extraordinary to me.
I'm saying that the attorneys had an obligation to discuss, and I'm not saying the architect doesn't know anything about the loft law.
I'm sorry, I thought you just said that. Maybe I misunderstood.
No,
Yeah, I thought you said that too. I thought that was interesting.
So
now with double.
I'm not impugning the architect. The architect's level of qualification is not in this record, and that, I think, was my point, and I apologize if I misstated it. His level of sophistication is not in the record. What we do know is they took absolutely no steps to talk to the architect until it was much too late.
On another point, Mr. Goldman argues that the form couldn't have been withdrawn.
I'm sorry?
Form could not have been withdrawn. That's the argument. How do you respond to that?
He's mistaken. There's no law cited for that. It's not correct. And
So would we need an expert, maybe on the law, to tell us about those kinds of things?
I believe that expert testimony on the law is going to be appropriate when this case goes forward, yes.
You know, I just looked at my notes. Did you sue the architect?
No,
You did not. I'm mistaken then. So
No,
why
I did
couldn't you
not
get
sue
an
the-
affidavit from the architect?
I'm sorry?
Why couldn't you get an architect affidavit? The affidavit from the architect who was doing all this work? To just flesh out some of these arguments that the movement was, that the appellant is making.
I don't believe that was our obligation. They have a
Okay.
prima facie
Got it.
burden on summary judgment. They didn't meet it. One other thing before I stop, I know I'm short on time. We did not concede the counterclaims. I don't know where that's from. We addressed that in the brief. Thank you.
Okay, thank you. Mr. Goldman?
Yes. Thank you. A few things. Number one, if you look at the complaint, it's one thing and one thing only. We did not get an extension by December 25th. Number
Right, but
two,
that was in part that it was in reliance, that the reason you didn't make an application for an extension was because you simply relied on the architect's certification without making inquiry.
that's, again, that's what you're saying. That's not in the complaint, and that's not
No, I
in...
think it's implicit in the complaint.
Well, it's, okay, it's not in the complaint as a pled fact. It's not in the attorney affirmation, which is insufficient to oppose summary judgment. It was raised by the court below on its own. And why is there no architect affidavit? Because it really made no difference at the end of the day. Why? Assuming we could have even filed and withdraw the 7B compliance form on August 20th, when we architects said,
Oh, no, but see,
No,
see,
but
I
May.
disagree with that date, and I don't know
Okay.
when your client was on notice.
August
But
20th.
clearly, January, as Justice Schulman pointed out, January 2021, you're sued, so you know there's a problem. Tenants aren't paying rent, and of course, what they're arguing is that there's non-compliance.
no, we're not sued in Jan. We,
No, you sued the tenants.
in May, in May of 21, and on May 17th, they file an answer in that case.
But when you sue them in early May, I thought it was January, I'm mistaken, you sue them, you know they're not paying rent. And you, as an experienced attorney, know why they're not paying rent, because they're claiming that you're not 7B compliant. So what do you do then? What are your obligations then?
You prove that you are 7B compliant, and the perfect answer to all of that is, since we were removed as counsel in August of 21, was an application to withdraw the 7B compliance filed with the loft board? No.
Well, why, I'm baffled by your saying that this was a surprise to you in August when the tenants asserted in May, asserted in their pleadings in May that the building was not compliant. Certainly at that point, I mean, I think you should have been on notice earlier than that, but certainly at that point, I'm having trouble understanding why you weren't on notice then that there could be a problem. And while I have you, I'm also curious, I don't know of anything in the loft law that precludes a party from withdrawing a certification and saying, oh, we made a mistake, we'd like permission to withdraw this. Is there anything that says you can't do that?
The only application, the form application that requires an extension is only if you haven't satisfied.
But is there anything in the loft law that says that you cannot make an application to withdraw something that you filed?
Honestly, Your Honor, you can make an application to do anything to anyone at any time. And the question is, has North Flats stated to the loft board they'd like to withdraw it? No, they doubled down and they continue to say they are 7B compliant.
But you were their lawyers.
But I'm saying when we were relieved, Your Honor, one would think if they wanted to withdraw it because they're not 7B compliant, they would start withdrawal.
You know, it's an interesting question. I think that might go to proximate cause, but don't you think discovery should be had before we address that really on a full record?
Well, when you say discovery, in order under 3212 to get discovery, there has to be an affidavit as to what needs to be sought, and there's nothing particularized as to what it is in discovery that needs to be sought. Is it whether or not, like Your Honor indicated, you can just make the application? That's not in discovery. We concede we didn't talk to the architect. What is it in their papers that they indicate that would require discovery? They don't even have their own architect submitting an affidavit as to what he knew or didn't know, or what the issue was. And again, this record is based upon the pleadings. No affidavits, unverified, and you can imply anything into a pleading. That was not their argument in their complaint, and it wasn't their argument in the court below.
Okay, thank you. Thank you both very much. The next case for argument is Augusta versus Abraham.
Good afternoon, and may it please the court. Joshua Krakowski for the defendant appellant. The trial court got this one wrong. It granted summary judgment without recognizing the language of the contract. This is a pretty narrow dispute. It's
What
also
about paragraph 13 of the contract? I mean, that basically says if the buyer is in default, then the seller can terminate the contract. I don't see why that's not implicated.
well, Judge Gesman, that's a good question. There was no default because what the argument is.
When she chose not to attend the meeting with the co-op board, wasn't that a default?
Well, no, because we canceled the contract prior to that. Now, 16.1 and 16.2 in this contract, it's essentially a time of the essence clause, right? I mean, time of the essence, when you have a real estate contract, you send a letter saying closing's got to be in 30 days or else it's canceled. This contract included basically that whole idea of time of the essence in the contract.
Yeah, but the adjournments were at the behest of your client. It was put over, the closing dates were put over because of your client's activities, right? It wasn't as if the seller kept pushing the date out, unless I read the record wrong.
No, I mean, nobody adjourned this. There was no adjournment. So there's two time periods at issue here. First, there's the contract that says this needs to be closed in 60 days or else either side can cancel it without penalty, all right? And the seller, both sides are protected because the seller can adjourn it for 45 days. He could say, look, we didn't close in 60 days. Let me exercise my adjournment, extend it another 45. That never happened. So the only relevant time period here is the 60-day time period that's set forth in 16.1, 16.2.
And what does that section concern, section 16 of the contract? Does it concern, whose inabilities does it concern?
The seller's inability.
I'm sorry?
The seller's inability, right. And I guess that's where the rubber meets the road here. It's the seller did not get co-op approval. And that was an absolute.
Seller has to get co-op? Come on, Counselor, come on.
I'm not saying.
Let's just,
Where in?
many of us probably live in co-op, so please.
All right. I misspoke, okay? The seller doesn't have to get
I think
co-op
every
approval.
co-op board shuddered at that moment, or every seller shuddered at that moment.
Yes. But the provision says seller's inability. It doesn't say seller's fault. It doesn't say seller's responsibility.
What did the seller, what was he unable to do?
The seller was unable to give us the shares for the co-op.
So in other words, you could do nothing. You could show, you could not even file a board application. The time expires, and seller can't claim a default. You get your money back.
Well, no, not necessarily.
That's what it sounds like. What you're arguing.
Because here in the contract, it prevents that sort of conduct from happening. You look at section 13 of the contract, it says we have to operate in good faith. Schedule the board interview, proceed in good faith.
Well, how did you proceed in good faith? You schedule a board interview. She needs to go to Israel. They adjourn it, and then she decides not to go through with it. Doesn't go through with the board interview.
Right.
How was your client acting in good faith under those circumstances?
Because the 60-day period had lapsed.
But the reason it lapsed is because your client, because the seller was trying to accommodate your client, not the other way around.
No, no.
So it was her failure to comply with the deadlines, and the seller maybe was a little more lax than they should have been in extending the time for her to comply, but
No good deed goes unpunished, I guess, right?
Well, no, I think, look, the reason that I don't know why they didn't adjourn the closing.
They did
you know?
adjourn it.
They
They
did
put it
adjourn
over for, they did put the date she was out in Israel, so they had to put it over for another date.
They never exercised the adjournment. They have to say, we want to exercise this adjournment.
Okay, so then how did they not turn over the shares? What was the seller's, what is your argument as to why the sellers breached because they didn't turn over the shares?
It's the same thing as this court held in the Perez-Gurry case. In the Perez-Gurry case, the seller couldn't remove a Department of Buildings permit.
That's not in this case. Is that in this case?
That's a 2020, that's a, this
No, in
court-
this case,
Right.
we're talking about this appeal.
Right.
What happened in this appeal? Was there a DOB, violation or something that prevented the seller, if the buyer had gone through with the deal, to turn over the shares?
Well, here, the timeline, well, the answer to your question shortly is just that they didn't get the co-op approval. There was no co-op
How
approval.
you get a co-op approval if your client doesn't show up?
Because the 60 days had lapsed.
wait, but you keep saying, you again said that it was the seller's obligation to get the contract approval.
No, no, no.
To get the co-op's approval.
The si-
That's
you-
not how it works.
And you're relying on purely the expiration of the 60 days.
Right.
Because once the 60 days expired, it doesn't matter at that point whether or not the co-op could the seller could turn over the shares, because the 60 days expired, and therefore my client prevails. That's your whole argument is based on the 60 days expiration.
It's very
That's,
simple.
but that's on the seller's inability to do something or to complete the deal in 60 days. And I'm asking you again, what was it in those 60 days that the sellers could not turn over the shares?
Again, what the sellers did, I don't think they did anything. I don't think it's their fault, but this provision.
What else could they do other than sit and wait for your client to show up?
So we're getting.
You must be missing something. Maybe
No,
I'm
I know. I
missing
think you're
something.
missing the time frames here. Okay.
I got the time frame.
Understand the timeframes.
No,
The
so-
question is
so-
whose obligation it is to do something.
So
Just to add on to this point, wasn't
piling
there an
on.
obligation in the contract for your client to meet with the board? Wasn't it section 6.2.2? And there was a firm date to meet with the board, and your client couldn't do it because she was in Israel? Yes or no?
right.
So there is an affirmative obligation on the part of your client in order to get to the promised land of getting the shares to meet with the board, because you and I know that co-ops aren't turning over apartments or allowing these kinds of deals unless they're satisfied as to the bona fides of a buyer, correct?
A contract is a contract.
Well, that's
You
my
have to
point.
look at the
So your
language.
client breached the contract. She didn't show up.
Here, the issue is, so the closing had to occur by July 1st. They're saying.
Why did you continue all these discussions and arranging appointments if it had to close by?
Because we hadn't decided yet whether or not we wanted to cancel, but we had the
When did you
unfettered
submit?
right to cancel.
I'm sorry.
Go ahead.
I didn't mean to cut you off. You didn't, you actually submitted your board package at the end of July.
No, it was submitted on July 11th. It was submitted first on June 23, so there was, some minor discrepancies. 18 days later, they admitted that we submitted a full board package, no issues, okay? So that's an 18-day delay. So it should have closed on July 1st. On July 2nd, either side had an unfettered right to cancel in the absence of the exercise of an
But you
adjournment.
didn't. But you didn't. You submit a second application on July 11th. You're supposed to meet the board on August 4th. Nothing about cancellation.
Well-
Then it's adjourned because of the stuff with Israel.
Judge
You
Singh,
didn't take those steps. It's like it's all, after she decides that she doesn't want to go through with it, now you're looking for ways to attempt to find cancellation.
well, once she had the unfettered right to cancel, what you're saying, Judge Singh, is that, somehow her subsequent actions waived that right.
So you're
I'm
saying
not saying
that
anything.
after the seller had gone out of its way to participate in adjourning it so that she could get in front of the board, she could still cancel at any moment and disregard all of her obligations under the contract?
That's what
Is that your
that's what
position?
16.1 says. It's 60 days, time of the essence.
Okay,
It says time of the essence?
No, but it's effectively the same
I
law.
think that was a question that I was going to ask your adversary, but maybe she'll answer it.
Okay, why don't you have a seat? We'll hear from the respondent. You'll have a few moments on rebuttal. Thank you.
Good afternoon. I'm Carol Ann Herlihy, Kellner Herlihy, Getty and Friedman, for the sellers and the respondents here. On July 1st,
The 60 days, he's hanging on the 60 days that either side, after July 1st, had the unfettered right under the contract to cancel the contract. And the fact of the matter is, that's where it stands, right? And that you're not entitled to keep the deposit.
that's what they say.
Right.
Right.
That's not what we say. We say, first of all, it's 45 days, not 60, but that never started running. That would have started running if on July 1st, which was the initial on or about closing date, if the seller had an inability on that date, if they had a tenant still in possession, if they had a DOB violation, if they had a tax lien, like we see in the other cases, if they'd had a disability like that on
That they
July
couldn't
1st,
cure at that.
then we'd get a 45-minute cure date. And if we still couldn't do it on the 45th day, which would be August 15th, at that point, either side can cancel. And that's what Perez-Gurry says.
Now, that provision, does that give your adversary's client the right to cancel?
Either side could cancel. If the 45 days starts running if we have a problem on July 1st. If seller can't close on July 1st, 45 days go by. If seller still can't close because they still don't have that tenant out, don't have the DOB violation cured, at that point, yes, either side can quit. But what we say is the 45 days never started running. We never had this sort of de facto time of the essence because we were never had an inability to close. We didn't have the problems that Perez-Gurry and the other cases in my brief cite, the tenant, the violation, the tax lien. We didn't have any of those problems. We were standing there ready to close with our stock certificate and lease. And
She never showed up.
and before that, the reason the 45 days never starts running is on July 1st, which is an on or about date, we're ready. She has not put her package in. She didn't put her package in on June 23rd. On June 23rd, she gave a draft to seller's broker who pointed out there's a lot wrong with this, not little things. There's a $100,000 discrepancy in your initial offer and now your finances. Please explain this six-figure discrepancy. This is going to be huge to the board. So it took 18 days to get, it never got submitted until July 11th. So what counsel says is that on July 1st, our on or about date, since we didn't close, because the package isn't even in yet, it was our duty, says appellant, it was our duty to exercise this 45 days, open the door to the time of the essence, open the door so that defendant can cancel 45 days from now, 46 days from now. That's not the remedy. That's not what we had to do on July 1st. We didn't have to start the clock ticking on ourselves. And your decision in a Glanzer versus Altman, you know what the remedy is when the buyer hasn't put the package in on time? They're in default, we can keep the deposit. We didn't do that. We didn't elect to do that. We elected to stay with the deal, try to make the deal happen. But I raise that because they would say the very conduct that would entitle us to declare them in default and keep the deposit, that's the conduct that lets her say we have an inability and I get my money back. And that just can't be. The same conduct can't both trigger our right to keep the deposit and give her a right to get the money back. It's one or the other. And the Altman versus Glazer says, it's her default, it's not ours. Thank you, Your Honor.
Okay. Counselor, you have 2 minutes in rebuttal.
Thank you, Your Honor. So 16.1 requires two things that I think are being overlooked here, okay? I'm talking about a 60-day time period. It has to close by July 1st. And then in 16.2, it says if seller does not elect to adjourn the closing, they don't get the 45 days, and they have to elect to adjourn it. And I think what counsel just said is telling they decided not to adjourn it because they didn't want to start the clock, but the clock had already started. The clock started.
But they gave your client more time to get in her board package. So again, we go back to no good deed goes unpunished, as opposed to going back to the, I don't understand how you think that that relieves your client of any further obligation to comply with her obligations and means that they're on the hook to give back the deposit regardless of how your client behaves.
Well, so when the 60 days lapses on July 1st, okay, say we're in breach, okay, it's an 18-day delay. So let's toll.
Your client still hadn't submitted the board package at that
So
point.
then-
So obviously you couldn't close when your client hadn't even submitted a full board package yet.
This is the contract they entered into. So what happens to the
Wait, but
60?
your client had an obligation to submit a board package. She hadn't done that by July 1st. So are you saying it would have been that they had no right to give your client more time to comply?
They gave us 18 extra days to complete everything. So let's add 18 days afterwards. We're outside 60 days.
But then once you submitted the application, they weren't done. You weren't done. She still had to meet with the board. So 18 days wouldn't have done it because your client was still out of compliance.
Well, then why agree to the 60 days? Think about this. What happens to the 60-day time frame? Okay, there's 60 days, you have to close it. On day 52, we're in breach, okay? So then what happens? What happens? Does it restart? Does the 60-day time period vanish? It's still there. So it's still there. It's 60 days. No adjournment was exercised. So if you don't close in 60 days, that's it. So we're 18 days late. Let's add 18 days from July 11th to July 29th. I mean, what happens? And we still cancel it after that date. What happens to the 60 days? Is it meaningless?
Throughout that period was acting as if there was still a good contract. Now you're saying we had the right to cancel, but you didn't. Instead, you kept trying to make it work.
Well, that's a waiver argument. We never did anything, and that's not even an argument that we waived our right to cancel. Nobody waived their right to cancel. There's a 60-day time period here, and this is the contract we all agreed to. All right, we know that. Look, co-ops take time. We all know that. All right, they're not going to do something overnight. Why
Well,
agree
they
to this
certainly
provision?
can't do it if you don't give them their package, so that's problematical. Listen, I think we were going around and around a little bit now. We have both of your points in your papers. We'll certainly take a look at them.
Thank you,
Again, thank you both very much. And our last case for argument is Parlux Fragrance.
I was thinking we were done.
Good afternoon, counsel.
Good afternoon, Your Honor. Anthony Viola from Mintz-Levin for the plaintiff's appellants. After all is said and done, there's only three things that this court needs to focus on in order to find that our appeal has merit and a new trial is warranted. And they all come out of the prior decision by this panel, by members of this panel, by this court in this case. The first is this court decided that the provisions at issue are promises, not conditions precedent. Very clear.
That's an argument that you pressed before us, correct?
Excuse me, Your Honor?
You pressed that argument before us on the motions for summary judgment.
And this court agreed that the...
Okay, you pressed those arguments before us. Is that
Yes,
a
Your
fair
Honor.
statement? Why didn't you make those arguments at trial?
I think, Your Honor, that this court's 2021 decision in Demetro versus Dormitory Authority answers that question. That's a case which is virtually identical. There was a summary judgment decision, an interlocutory appeal. Before this court issued its decision, there was a trial and a verdict. Then there were post-trial motions, and the issue of the effect of the interlocutory decision was raised with the trial court in the post-trial motions, which is exactly what we did. And this court in Demetro said that on the second appeal, it was proper for this court to determine what the effect of its interlocutory decision was on the trial. It's important to remember this
I don't know what occurred on that trial, Counselor, but what I do know in this case, you did not object to the jury charge. And that kind of really sort of colors my opinion of the merits of your argument. And you know, there are arguments to be made. And it's not something that you did not know, because that's the argument that you were pressing way back on the summary judgment stage. And it seems to me that the trial attorney had an obligation to at least note a specific objection to the jury charge in the way it was given, since it was completely inconsistent with your position.
And to add on that point, there was a motion to stay by the defendant of the trial, which you opposed, which, you know, if you know that on appeal, the condition proceeding was such a substantive issue to resolve, because that would be shifting the burden as to who's going to have to prove what at trial, you opposed that motion to stay the trial.
I would like to answer both of those questions. And there were many issues that were the subject of the prior appeal.
Yes.
Not just this one, there were many issues. And we opposed the motion for a stay pending appeal on the basis that the defendants had brought it too late as part of a gamesmanship in the litigation. They agreed to this was an appeal and a cross appeal, so we had to negotiate with them the timing. We did everything we could to get this heard pre-trial, including getting it briefed, argued, perfected pre-trial. Now, the trial court denied a motion for stay, and this court denied a motion for stay.
But what we're saying is that you did oppose it. I mean, had it come up to us and both sides said, you know what, I think that makes a lot of sense, because this is a very important summary judgment motion that covers many, many issues, and several of us were on that case, so we remember that. That's what we're saying. I mean, you're right, we denied it, but you opposed it. What if you hadn't opposed it, we might have looked at it differently.
Well, again, we opposed it on the basis of the timing and the circumstances under which it was made.
Yeah, but opposing it is opposing.
I'd just like to follow through with the question about what would happen had an objection, you know, so been made. We're sitting at trial, pre-trial, and what the defendant's argument is, we should have objected to every pretrial ruling, every jury instruction, every charge on the basis that there's a pending appeal, which we don't know how it will come out, and maybe it will affect this trial. And the trial judge properly would say to me—
Maybe you could ask the court for a continuing objection on that ground, but that didn't happen either. I mean, one can do that.
We took an appeal, Your Honor. I mean, we perfected an appeal.
But an appeal is not an objection to a jury charge. There's a basic preservation problem that you're facing now, and unfortunately, it's one that was caused by your side.
Again, I'd like to go back to the Metro case and what happened here, which is that we obviously could not know what this court would rule until it ruled. When the ruling came out, we promptly brought it to the attention of the trial court, where post-trial motions were still pending. All of these issues were presented to the trial court. We had a directed verdict motion pending. These issues should have been considered by the trial court. They were preserved on the post-trial motions and should have been considered by the court post-trial at a minimum. And we have appealed that ruling, which is clearly before the court, and the issues are preserved on the post-trial motions. And that's exactly what this court found in the Metro.
But the problem is, Counselor, we go back. I mean, it's like a Cohen versus Hallmark argument. We go back to the jury verdict. Was the jury verdict irrational? I think that's kind of what we're looking at. And then we look at the issues. Were there objections made to the jury interrogatories? Were they preserved with respect to the jury charges? And then I think then you have a much better argument to make to us. But in this circumstance, preservation is a problem.
Sir, even in the instructions to the jury, did the court give the jury the heightened standard that would be applicable to a condition proceeding versus substantial compliance? Did they use the heightened standard of, even though the court made reference to that term that you feel is a problem here?
This court ruled that the provisions are not conditions precedent.
That's my point. So your argument is that the court committed error in making reference to the obligation to submit plans or to give notice to the defendant by referencing them as condition precedent, that was error. That's your position during the course of this
It's
trial.
error, and
So that's my point. So say there was references to that term, condition precedent, to those two contractual obligations. Did the jury instructions advance the higher standard that would be applicable to a condition precedent?
absolutely, absolutely, Your Honor. The jury instructions told the jury that we had to prove compliance with the conditions precedent before they could consider our breach claims, and that's wrong. And
Sir, but didn't the instructions say substantial compliance?
That's what
but we had no burden.
No, I understand, but then we get into the whole thing about not preserving it. But my colleague's question is didn't it, in sum and substance, say substantial compliance, which is not a condition precedent, correct? Because if it's a condition precedent, as we said in Parlux, you gotta comply.
I'm reading from page 3680 of the record, the transcript. This is part of the court's trial instructions.
Page what?
3680. Actually, let's just go to 3694. You've heard evidence that plaintiffs had an obligation to provide the defendant with a product development plan. This obligation is what is known as a condition precedent. Here, I've already ruled and required to accept plaintiff's obligation to deliver a product development plan to defendants was a condition precedent to defendants' obligations. Next page, 3695. Plaintiffs have the burden of proving that they satisfied the condition precedent to deliver the product development plan.
And I agree that's wrong.
That's
but,
wrong.
But all I'm saying is that the term substantial compliance is in there, which suggests that it isn't a condition precedent. That's all I'm saying on that point.
The court clearly stated multiple times it is a condition precedent, and in any event, it was confusing. And I'd like to just go back to the preservation issue. One thing I forgot to say is that, assuming you disagree that taking an appeal is not sufficient to preserve the issue, there is a fundamental error.
Well, is there a case? If there's a case that says that, then that's fine.
The Metro and the defendants have no case, by the way, which says that we had this obligation. They found no case. We found the Metro, which says the opposite. And there's also the issue that this court has the right and duty to correct the fundamental error. There's no dispute there was a fundamental. I mean, the defendants try to misread your prior decision, but I could quote from it. I'm sure I don't need to since the three of you are on it, but it says very, very clearly, these provisions are promises, not conditions precedent. And so there is the fundamental error issue. And finally, I'd like to say there's also, the other thing I wanted to say is that, which comes out of this court's decision, is that these are all therefore, everything you're going to hear from the defense side are affirmative defenses as to which they had the burden, which cannot stand as a matter of law, as this court said, if they did not terminate the contract in the face of those claimed material breaches. And it is now established beyond purview, beyond dispute, that the defendants never terminated the contract and never invoked the termination provisions of Article 15. They never sent default notice. So every fact issue that they are going to attempt to raise relating to their defenses is irrelevant as a matter of law under this court's decision.
Why don't we hear from the respondent? You'll have a
Thank you,
little
Your
time for rebuttal. Thank you.
May it please the court, Elodie Thompson, Quinn Emanuel, Urquhart, and Sullivan on behalf of respondents. I would like to start with the preservation issue because I do think it decides the question of whether any new trial should be granted, and the answer is that it was not preserved. It's not a matter of case law per se, it's a matter of the CPLR. The CPLR is very clear that objections to jury instructions must be raised with the trial court before the case goes to the jury. That's in CPLR 4110-B. It's also the second part of 4017.
What about the case that your adversary has mentioned several times, the Demetro case? I mean, does that say what he says, that there is a different way of preserving it other than saying objection, Your Honor?
No, Your Honor, that case is not about jury instructions or objections to jury instructions at all. In fact, the Demetro case is consistent with the trial court here ordering judgment in favor of defendants on their counterclaim, consistent with this court's ruling that judgment should have been entered. So it does not stand for any excuse to a failure to object to jury instructions. In fact, if the court looks to CAPLR 5501, 5501 says that the scope of this court's review is limited to any charge to the jury or failure or refusal to charge as requested by the appellant to which he objected. So this is very clearly set forth in the CPLR that it must be preserved. And why is it so important to preserve? It's not a technicality. It's so that, exactly as this court was indicating, if the trial goes forward, the trial court knows that there are issues that the later appellant has with the jury instructions so that the court can address it. How could the court have addressed it here? Well, it could have granted a stay of trial, but the court also could have had the jury continue on through the verdict form after answering any questions that appellant here, plaintiffs claim were erroneous. In reality, there was not even an error in the jury instructions, and that's for two reasons. One, it's because, as is noted on supplemental record, page 56, the plaintiffs proposed the substantial compliance instruction for the product development plan. And further, the court, when it gave the condition precedent instruction, put that label on, but it was substantial compliance. Not only that, but if the court looks to record page 3702, what the court says is substantial compliance with a contract or condition precedent does not require a party to comply with every technical aspect of the condition precedent. Rather, what is required to comply to the extent of its general intent. That is not a condition precedent instruction. As to Article 11E, the court did not instruct it was a condition precedent at all. There was no instruction or even reference to the label of condition precedent. The only reference to a condition precedent was defendants make some.
But did that switch the burdens up? I mean, that's the argument, that we were required to prove something that we should not have been required to do.
Well, a party always has to, as a part of a contract claim, prove their own performance. And if we look at Article 11E, the provision related to personal appearances, sure, this court held that the requirement that there were 20 business days written notice, that was not a condition precedent. This court did not hold that there was no requirement that plaintiffs advise Mr. Carter of when he was requested to appear. There could be no breach of that provision if there was no date on which he was requested to appear. He can't, doesn't have an obligation to appear on a date he wasn't requested to appear. So it simply is a matter of showing their own compliance with the contract. It was not a matter of burden shifting. Of course, to the extent any affirmative defense were to come into play, that doesn't happen until there's proof of a breach that occurred. There was no proof of a breach that occurred here. If I just may briefly address the royalty counterclaim, this court previously held that defendants were entitled to judgment on that counterclaim.
They stipulated to the amount pretty much.
Yes, Your Honor, they stipulated to the amount.
Actually, I think the judge ended up signing the counter-proposed judgment from what I could tell by looking at it.
Yes, Your Honor, the judge did sign the counter-proposed judgment. So there's really no dispute here. They raise an issue with whether that was in the complaint. The complaint at record page, the answer and counterclaim. The answer and counterclaim at record page 58 says presently including up to an amount. And of course, in an interrogatory answered 3 years before trial, it was very clear that defendants on their counterclaim were seeking the entire guaranteed minimum royalties for the 5-year initial contract.
One of the things that the agreement dealt with, and I don't know if it's 7C, that was the production management plan, the PDP.
Yes, Your
and
Honor.
that they were supposed to give them that before they knew how they were supposed to proceed with that. And it sounded to me, and correct me if I'm wrong, that the testimony that came back was a little bit back and forth, but the CEO of Parlux wasn't even sure what a PDP was supposed to be, or if they really gave it, or what it even was, or what it consisted of. So, I mean, the fact of their having to prove it was very murky kind of testimony. And they didn't really show that they had given it to them, so that there was something they really should have been doing that they weren't doing. And the jury heard all this. So even if the exact standard was not where it might have been had the trial been after this decision, then it may not have made a difference. I don't know if you can address that, if that was how I read it, but I could be wrong.
Yes, Your Honor, absolutely. Even if there was any error, it would have been harmless error. First of all, for the reason Your Honor was describing, but second of all, because in the prior appeal to this court, the court dismissed as duplicative the breach of the duty of good faith claim. The jury here, because the First Department decision was not received until after the jury rendered its verdict, found that there was no breach of the duty of good faith. Article 7C, what plaintiffs has alleged, the breach was here, and of course why this court properly dismissed it as duplicative, is an obligation for the parties to work together in good faith to develop products to be approved in accordance with the product development plan. So even if there were any errors, such error would have been harmless.
And the jury had the opportunity to hear from Mr. Carter and I think Ms. Perez, I think her name was, as to how they were working and analyzed the fragrances and the colors and the whole gestalt.
Yes, Your Honor.
Fair enough.
That's exactly right. There was feedback provided. There was an ongoing discussion. And not only that, but when we talk about good faith, there was also, of course, evidence related to whether plaintiffs were acting with their good faith in proposing and working on further product extensions. If the court has no further questions, we request that the judgment be affirmed.
Okay, thank you, counsel.
There was allusion to the purposes of the preservation rule and that the trial court be aware of the issues. The trial court was certainly aware of the issues. He had made his summary judgment ruling and knew that was on. He knew that an appeal was pending. A motion to stay was made by the defendants to him, and he denied it before we even had an opportunity to respond to it. He said, I am not going
The
to.
CPLR doesn't permit you to not make objections if you think the trial judge already knows what's on your mind. It requires that you make objections.
Again, Your Honor, what objection should we have made? That maybe something on the appeal might affect what is going on at the trial? And the trial judge's answer to that is...
No, your objection would be that we object to charging a condition precedent.
Because we don't believe that I mean, your arguments hadn't changed. I mean, yes, it was a pending motion, but I assume your position was still the same afterwards as before, that we don't believe that there is a condition precedent. We just want to put it on the record that we think the charge is not correct. The judge could then have had an opportunity to make a little tweak in his charge, thinking, oh, well, it is up there, maybe I should do something. That's why we like to have objections made while you're still in the midst of trial, so a trial judge may make some tweaks or changes before the whole trial's over and you've spent weeks and weeks and weeks and you have to go back years later.
The precedent of this court is that a summary judgment decision is law of the case, even pending appeal, until it is reversed. What you're saying is that I should have told this judge that I object on the basis that his prior decision is wrong.
I wouldn't have said it that way if I were you. I would have said...
That's what the objection is,
No,
Your
I would have
Honor.
said, look, the judge knows the law too. He's a very smart judge. He knows that there are requirements for preservation. You were on trial before the decision came up, so he understood that. You say, respectfully, I object to this charge. I still maintain my position that that this is not a condition precedent, because everybody knew it was appealing.
And in fact, Justice Borak watered down the condition precedent standard. Because we all know it, you have to meet it. Here, he just watered it down so as to send, at least to me in my mind, when I read that, like, okay, maybe he's like, giving you a message that I'm not so sure my first ruling was correct.
Respond to something that counsel said. She said that the trial court never instructed the jury that Article 11 was a condition precedent, and that's wrong. I refer you to 3696, which the court says that the defendants have argued that it was a condition precedent to Mr. Carter's obligation first to make personal appearances, that he receive adequate notice under the license agreements. Plaintiffs have the burden of proving that S. Carter Enterprises received adequate notice. We had no such burden. It was the defendant's burden to show that there was something wrong with the notice. And again, I come back to, we filed an appeal, we preserved the objection. It would have been fruitless to make this objection to the trial court, who knew exactly what he was doing. And the Metro case says we didn't have to do that, and it was fundamental error, which this court can
On the
review.
verdict sheet, the term condition precedent was not used. I mean, I understand that it was used at some points during the instructions to the jury, but the term was not written down on the verdict sheet.
The term was not, but the burden was placed on the plaintiffs, which is incorrect as a matter of law. It says the plaintiffs have the burden both on C, on 11E and 7C. The court said the plaintiffs have the burden to prove that what they did was adequate, and that is wrong. If the defendants clearly knew that Mr. Carter was requested to make appearances, he admitted under oath that the document he received it's a run of show. He knows what that is. He's in show business. He understands it's the schedule of the day. He understood that that was a request for him to appear. If the defendants felt that there was something wrong with that request, no matter what it be, that it was a draft, that it would call for 3 things on one day, no matter what, if they felt that it was deficient or defective, not in compliance with the contract, it was their burden to convince the jury that that was immaterial, and it was also their burden, which they cannot possibly meet, to show that they didn't elect to go forward in any event. Because under this court's prior ruling, they had that document, they knew it was a request, they did not take any steps whatsoever. Same thing is true with the product development plan. The defendants under Article 7, they knew full well that they were being asked to approve products. They said, we don't approve it. Clearly they knew they were being asked to approve things, and they knew what the provisions of the contract were. They say they asked for a product development plan and did not get it, and yet they continued with the contract, did not send notice of default or termination.
Okay. All right, thank you both very much. Have a good afternoon.
Yeah, he was like this. The head went like this.
You don't realize how close everything is now.
Yeah, no, that's what I'm telling you. The guy, and she actually, I thought she was gonna say something. She was like looking like this, and I was trying not to laugh because he was cracking him up.